For Creamer Media's Polity, I'm Shannon de Rehove, Vice President of the Federation of African Professional Staffing Organisations, Casey Makubela, joins me to discuss the amendments to South Africa's labour law and their effects on employers and employees. What are your main concerns about the new amendments to the Labour Relations Act, which came into force at the beginning of the year and which deal with temporary employees?
My biggest concern and our biggest concern as EPSO is that it has been misinterpreted, and it has disrupted and it continues to disrupt the temporary employment landscape in South Africa. So what has happened is that many of the organizations who have been successfully using the TES or Temporary Employment Service organizations suddenly find themselves in these waters that are murky because they misunderstand what it is supposed to mean, and they have made decisions which I feel that are rash decisions which will impact on the successful growth of their organization and therefore the economy of the country. So really it's all about the misinterpretation of what the act or the acts are supposed to mean.
The amendments contain a so-called deeming clause whereby temporary employees can be deemed to be employees of the client company rather than a temporary employment service. What is the purpose of this deeming clause and how do you think it should be interpreted?
Well, first, let's put this into perspective. There are about 4 specific acts that are designed to regulate the industry that have come into effect in the past few months. So you've got the Employment Equity Act, you've got the Basic Conditions of Employment Act, you've got the Employment Services Act, which is still yet to be made law, as well as the Labour Relations Act. The particular clause that you're referring to, the deeming clause, is an act that is referred as Section 19A and also linked to Section 19B. Now, what it actually says is that after 3 months, the particular employee that is employed by a TES is deemed to be an employee of the client. Now, I want to make this very clear. When you look at the particular clause, the way it has been put together, it does not refer to the employment of that particular employee being transferred to the client. It does not in any way speak of the other acts like the COID Act, like the UIF Act, the Skills Development Act, many other acts that are linked to employment services or employment of an employee. It does not transfer that relationship between the employee as well as the employer being the TES. So that is the act that we're talking about. All it talks about and the clauses that it talks about in terms of permanency is the indication that there should be equal treatment in terms of this particular employee if you compare that to the employee of the client. It also speaks about the payment side or the remuneration side, where it talks about equal pay for work of equal value. Now, can you imagine, in terms of the Department of Labour, if they wanted to make it so clear, and if that's what the intention was, they would have said the employee is a permanent employee of the client, and it does not refer to that at any particular, in anywhere in the Act.
What is the problem with that? Is it because then the client doesn't want to take that person as a permanent employee? Is that the main reason? I know this is off the topic, but I'm just...
Yeah, it's not the main reason. It's really that you must understand, when you use TES, you are using them for projects, you are using them for seasonal requirements of business, but also you are basically outsourcing your HR function. You don't want to have to retain a fixed cost in terms of your HR side of things. You want someone that is a specialist in dealing with the employees, and rather your organization and your operations concentrate on the business, as it were. So that's the main reason. They would prefer that a specialist company like a TES would manage their employee in this regard.
Why do you think your interpretation of this deeming clause is superior to other interpretations?
What we have done as EPSO and the industry is we have looked at various opinion pieces, legal pieces, specifically from 3 legal firms that have been obtained by industry or industry companies or members of EPSO. And these are reputable organizations that specializes in labor laws. And all of them interpret the way we have now come to understand the intention of the deeming clauses. Also, we've had senior counsels from our industry, CAPES in particular, that have been sitting in NEDLAC. So they've been part and parcel of the negotiation processes right from the beginning. So they understand the intention of what the law was supposed to mean or what the law says. So I've got here 2 reputable, I can put it, reputable sources, being someone that was actually part and parcel of the process from the beginning of the negotiation until the conclusion. Surely that should mean something. You've got 3 legal opinion pieces of people that were not necessarily there, but people that understand law, that have looked at it independently, and all of them have agreed that the way the deeming clause is being interpreted at the moment is not correct.
You state that the current interpretation of the amendments goes against government's intention to create decent jobs and support and grow black business. How so?
So if you look in our industry, the recruitment industry, we as APSO represent over 800 recruitment companies. Of those 800 recruitment companies, there are quite a lot of small, medium enterprises, which the majority of are made of black businesses. Now, if this law is being misinterpreted, what is going to happen is the clients of our industry are going to make the rash decisions which I referred to earlier. And in making those rash decisions, it's going to lead to them disengaging with these small, medium enterprises. That basically means the businesses are going to die. The businesses that are dying are businesses that are owned by black entrepreneurs. Now, if they're dying, it goes against exactly what the government is trying to do, to put impetus, to put encouragement for black businesses to actually be profitable and stand up. So that's basically the issue. We've seen this in our organization, where more and more of the members that are now leaving EPSO because they are folding are actually coming from small medium enterprises, and nearly all of them are actually owned by black entrepreneurs. And that's the problem in my mind.
What role do temporary employment services play in the South African economy? And are temporary employment services unique to this economy?
Let me start with the last part. They're definitely not unique. In actual fact, it's very strange that in South Africa, these laws are made to regulate our industry in such a way that it goes against the grain of what is happening in the likes of the UK and Americas. This is a growing phenomenon in those industries. And in my mind, having looked at what has happened in the past, South Africa is a follower. And I can almost assure you that the trend and the right trend is actually to allow the TES to actually thrive in this environment. The International Labour Organization, which is a very good reference point for anything that happens within our industry, within the country, actually recognizes the temporary employment services. They've got clause that refers to us, they've got regulations that refers to us, they've got good practices that refers to us. So it is definitely an international phenomenon. It's not a South African phenomenon. To your earlier question, or the first part of the question, think about this. If you've got an organization and you own a company, you want to partner with someone that is an expert in getting you resources that will allow your organization to grow and grow quickly. You don't have the expertise, you don't have the resources. The temporary employment services organization and recruitment companies that are not necessarily in the TES environment have got contact with a lot of people that are looking for it, because they know that's what we do. You as an organization, you don't have that. So it's a source and a resource for any organization that is looking for talent. Secondly, we have a good way and an understanding of how to match talent to your requirement and your objectives, something that you don't necessarily have. So we're helping that. But also we are bridging the gap between the unemployed, all those that are looking for employment, to employment, because we know where employment is. We know which organization to speak to. But also we are also making sure that when we match you to the job, we match you to the right job. In that way, we deal with the things like attrition. So now, can you imagine, I've taken you in and I've matched you to the right position of a job. You are happy, you stay in longer, you are helping the organization because you're not attriting so quickly. There is no cost of retraining and re-employment of somebody else or recruitment. But also because you are happy, your performance is high. Therefore, the organization gets to actually perform better. So that's what we do. We also have found that on the temporary employment side, the organization has got the ability and the opportunity to do what we call work in progress, or should I say interview in progress. You have an opportunity to use someone and you get to learn that person and see if they culturally fit within your organization, and then later on you give them permanent employment.
What would you suggest as a remedy to the problem of the exploitative practice experienced by some temporary workers? How best do you think the issue should be regulated?
I must tell you that this is one problem that we have in the industry. So APSO welcomes any act that comes to regulate our industry. The only problem that I must say is that these many acts that come in, there is no one that actually police this act. The government has got no resources to police this act. So we've got quite a lot of organizations that don't belong to APSO, as an example. And those I'm not saying all of them, but we do know that many of those organizations, because they're outside of the ambit of a regulator kind of an environment like APSO, they actually do things in a way that is not acceptable. So there's plenty of exploitation. What I think should happen, number one, is that somehow the people that are using, in other words, organizations that are using temporary employment service or recruitment agencies, they should actually use organizations that somehow are following the law. And the best way to do that is to say, are you a member of APSO? Because if you do that, at least you know that the person is legitimate and they do the right thing. That's number one. Number two, it is to make sure that they integrate in their request for proposal from recruitment agencies in their tenders that they put out. I'm talking about the clients. Make sure that they make a belonging to the likes of APSO a requirement. Can you imagine going to employ an accountant who don't belong to SICA? Can you imagine going to employ a doctor who don't belong to the medical association that they belong to? That's exactly what is happening. So what happens is that you go and employ these people, you go in and accept the partnership from a recruitment agency who does not belong to any industry body. You go on a very low margin, as an example. That's why what they do to make profit, they go and exploit the employees that they've employed. So what I'm actually saying, that the client themselves are actually encouraging the exploitation of the people that we're trying to protect. And by the way, in conclusion, the people that the law is trying to protect are what we call vulnerable employees. So these are employees that earn up to 205,000 a year. Those are the people that we're talking about in the industry. The last thing, I really believe government should support APSO as a regulator of the industry going forward, to make sure that we assist them in terms of the resources in regulating the industry and deal with the rogue companies that are there, and there are many of them.
Is there anything else you'd like to add?
What I would like to say is that the industry has supported the economy of the country for a very long time, and we will continue to do that. We do want to work with government, we do want to work with clients to make sure that the people that are in the industry and the vulnerable workers are not exploited. But at the same time, we want to support government to make sure that the regulations that are put in place are actually adhered to, and lastly, to make sure that the clients and the organizations in South Africa, companies and businesses, actually perform to the best by making sure that we recruit and employ people that can actually assist with the growth of those organizations. Ultimately, we grow the economy of South Africa.
That was Casey Makubela, Vice President of APSO, speaking to Creamer Media's Policy about amendments to South Africa's labour law.